I'm Matthew Kurbis, the subscription attorney, and this is Law Subscribed, your dedicated source for all things subscriptions and the law. Thank you to my sponsors. See links to them in the show notes. Everything discussed is only for educational and entertainment purposes. Enjoy the show. Okay, we're live. We're live on LinkedIn. Thanks everybody for tuning in. I know we've got dozens of you registered to attend. This is a special episode of Law Subscribed Live. It's I think in journalistic terms, it's called a first look, because just after Arbitrous AI went live, now I have some of the people involved with that, and I'll let them introduce themselves in a second here to talk about the future of private courts and the role that AI plays in as a judge for dispute resolution. So if you like these lives, and if you actually want to attend live, if you're watching this later on, make sure you follow all of us on LinkedIn, click on the bell, select all, so that you could always be notified when any of the three of us are going live. And if you're a podcast listener, just a reminder to do the same thing on LinkedIn if you want to participate in the live chat, because I'm monitoring the chat today for everybody who's here or who's coming in. And if you have questions, ask. Like, we've got the people behind the future of dispute resolution. So now's your chance to ask. So I'm definitely going to be taking questions from the live audience today. That's one of the benefits of doing these live. So having said all that, I'll go ahead and let my guests introduce themselves.
Yes, hello. My name is Kimo Gandall. I'm a 3L at Harvard Law School. I'm a professional registered parliamentarian as well, which is just basically fancy jargon for I interpret bylaws and help with Robert's Rules of Order or any parliamentary manual a client might have. I've also been working in this AI space for over 7 years now. I have several papers published on the topic, ranging from machine learning. We were manually labeling and mechanical turking before ChatGPT came out, before AI was cool and hot. And I have a lot of experience in the academic space and business space here. And so I'm the CEO of Fortuna Insights, and I'm very excited to have this conversation. Thank you for having us.
Yeah, appreciate you having us out, Matt. My name is Jack Kieffaber. I'm one of Kimo's law school buddies who has written a few papers in the space myself. Kimo writes more technically. I'm more of a sort of a theory guy, thinking, where's this stuff going, 50, 60 years from now? I'm a lawyer in DC these days, and yeah, I try to keep the company forward-looking as much as possible. Maybe a little too forward-looking. We'll see. We can debate just how far ahead we're looking with this thing.
Well, thank you both for coming, because I know things are happening fast and it's getting a lot of interest. And I'm actually super in favor of AI judges, right? Like this for me is not a conversation of should we have AI helping in the judicial process. And I'm even in favor of doing it in actual courts, let alone private courts, right? I just think we have to be careful, but also proactive and iterate in the way that we do this, right? And so my interest in having you on is not to answer the question, should we have AI judges? I mean, inevitably we'll talk about that, right? Because I still think there's going to be a lot of questions around that, and you'll be answering a lot of those questions, I'm sure, in the coming weeks and months. I'm more interested in the how. And my audience, my niche audience, which are futurist lawyers or legal tech entrepreneurs, that's, I think, more the conversation that they're interested in hearing as well. I know we're going to bring in a lot more people than just that, but that's my typical audience. So with that in mind, at a high level, because I've also listened to the paper via Descript's AI voices, how are you going about doing this whole AI judge thing?
Yeah, great question. So 2 parts to that question. First, on the user side, what they're seeing, and then technically. So on the user side, you simply go through a normal trial process. You'll upload your briefs. You'll have a discovery process. There'll be some sort of exchange. Often the parties don't agree on discovery procedures, interrogatories, discovery requests. Arbitrous will actually make a ruling on that if need be. And then the parties will have a final hearing. And then after that, Arbitrous will render a full ruling. Now, there's a big question on how does it go about doing that? And what we attempt to do is as transparently as possible, while also, keeping a little bit of our secret sauce, disclose that to users. So effectively what happens is we break down the briefs into issues of controversy, and then we match those to the relevant evidence. We have machine learning models flag pieces of those evidence for relevant components, and then we make a decision. And simply how a decision works is after we feature extract, that's the secret sauce, right? Not completely secret sauce, though. So our voting ensemble has a number of models in it. We've actually open sourced one of the models. I published a paper called Predicting Precedent It is one of the most simple models we have. So that is just a bag of words counter, right? We call it a psycholinguistic one. That's fancy jargon for it captures psychologically impactful phrases and then correlates them to court outcomes. And so we can actually take text and then predict off it. Of course, there's also videos, which are not text. Now, you can use AI to translate them into text, but in our opinion, that is not holistic of the decision-making criteria of real lawyers. And our goal in building this is to parrot the real process. So we also look at changes in pixelation. We actually have a number of different methodologies in which we feature extract from videos. We flag those relevant components of the video, and then a voting ensemble decides what is the probable result. So just like a human, it's looking at, changes in voice. It would see changes in pixelation, but we would equate that to changes in body language, right? Literally, body language just comes across as pixels. And a lot of this literature, by the way, has already been open sourced. You can literally look up deception detecting algorithms online that are open sourced. So really, the application here is building custom models for the law and then determining kind of what that empirical threshold is for a judge to make a decision. And then after a decision is made, we could talk about this later on the LLM side, which is controlling hallucinations. That's actually a different conversation dealing with the raw.ai system. We can even go into how that was named. It's actually very important. And then it creates a final ruling that is theoretically hallucination-free.
All right. So, Jack, anything else to contribute to that? I know you're more the theory guy.
Yeah, I'm trying to think of theoretical angle. It's key that most of the questions we get is, how is this thing going to find facts? That's sort of the standard LinkedIn post we get, how will it know if you're lying, yada, yada. Kimo laid it out pretty well. The way this thing just looks at pixels, breaks things down to little bits of data. I think in terms of just broader tech marketplace, what people should be putting money into is, how do we translate as much of the physical world as possible into data that an AI can eat and react to? I talk a lot in my papers about the metaverse. To me, this is what the metaverse is. It's you take your life, you put it into a space where everything is accounted for. It's video game physics. Anything you do in the game, some motherboard knows that you did it, such that there's never a factual dispute. You see this with speeding cameras now. You see it with sort of just the creep that social media and these big companies have in various areas. Google knows a lot about you. Mr. Musk knows a lot about you. I think there's a reason for that. I'd be shocked if these guys didn't have that in the back of their mind. That at some point, we can feed all this data to a machine to make decisions about you, what content to give you. Maybe someday we could discuss what laws to give you.
This is really interesting, and it goes to thinking like, well, if we're already living in a simulation, can't we just collect all this data anyway, right?
Well, yeah, the computer outside the computer, right?
But with the Internet of Things, with wearables, with potentially brain-computer interface chips in the future, like collecting this data is probably only going to get easier than it exists today to feed into whatever the future of this AI judge looks like in the future. Does that sound right?
100%.
Yes, correct.
Yeah.
Yeah, Jack, you take it away.
No, you see this a lot, and it's just a duplicate of what I've said before. The more of our speech that happens, speech is being one example. What's the most important speech law in America these days? 5 years ago, you're probably still saying the First Amendment. Any law student, anyone else probably going to say the First Amendment. I disagree. I especially disagree after the Supreme Court did a case called Net Choice recently, where it ceded a broad swath of just the Internet's ability to select content, what you see in this new physics of Facebook. We talk a lot about how law really is just sort of a contrived physics. Physics is a weird guy. If you want to commit some mass genocide, physics says that's great. If you want to go up, physics says, wait a minute, you can't do that, right? We patch physics. We don't like the genocide. We make up a law on top of that. These guys with Twitter, et cetera, have built a new physics. It's just a new thing we interact with. And as more of our action is happening strictly there, and as the government sees that choice, says, hey, that's a physics we don't have jurisdiction over. You guys make the calls. All of a sudden, that data gets a lot more usable. And also, what we'd be litigating over gets litigated strictly in those spaces, not outside of them.
Yeah. In a way, the future of dispute resolution, thinking about it from a metaverse perspective, you're looking at these terms of service that you're agreeing to when you enter these digital platforms, right? Like that's going to be the governing law, not that hopefully, we're not going to get political here. If there's an autocracy in the future where companies are running America, maybe that also becomes a law. But at least for now, those terms of service comply in some regard to U.S. law. But that's the future there. Well, you said, this is going to help figure out what's a fact. Well, what is a fact? Again, not trying to get political, just looking at the reality of
course.
It. What is a fact is a question of opinion these days. and like the physics of it all. We'll get into the physics part next, but let's just talk about that. So you said it's going to help determine like which facts are accurate. But if facts are just matters of opinion, how do you even, whether the color of a vehicle in a motor vehicle case, that struck you or that you struck, like that's something that's a fact, right? Then that's easy. But whether somebody's telling the truth, whether some other sort of thing happened, like that's a little bit harder to understand. So how does the AI go about, exercising this discretion?
Yeah, great question. So I'm going to give it kind of a theoretical overview of how this works. As a note, I can't give away all the feature extraction methodologies, but I'll give the ones that are open sourced. So for example, I always give the pixelation correlation because that's the easiest for people to understand. Literally how a lot of the studies work is you'll have a deception group and an honesty group. And then you'll have them film testimony, and you'll have humans predict which group is telling the truth, and you'll have AI predict which group is telling the truth. And then you'll look at which methodology functioned better, the AI or the humans. And the AI is just it's flagging changes in correlate pixels, and then it correlates it based on its training data. And its training data in the past has just been manually labeled groupings, right? So it's trying to mimic human experts and then eventually do better. So eventually you'll start feeding in new sources of data, and you'll say, this is a true case, this is a not true case, and you'll just do that over an extended period of time. And then you validate it off an actual experiment. And so that's a very simple overview of how it is. In what I'm actually saying, and this is a controversial point, is there is no more opinion. There's only probabilistic events. Mm-hmm. And so what our view is there's either event happened or event didn't happen, and then there's some sort of probability distribution given off that. So there's no more opinion with AI, and it just wouldn't make sense because all AI is doing is making decisions off the most probable sequence. That's how LLMs in text make decisions, most probable sequence of tokens, right? It's not an opinion. It's literally a mathematical function. This is how, we could dive into deep neural networks if your users want that, but yeah.
So let me jump in there because Jack also brought up the physics of it all. But really, it's more quantum physics, right? Because we're talking about probabilities. And the simplest way to know the difference between physics and quantum physics is in quantum physics, kind of anything is possible. But the thing that's happening, like that my hand isn't going through my desk, is the most probable outcome. But paying attention to it also plays a role, but we're not going to get into that level of quantum physics here. But it's all probabilistic is what it comes down to. And so I think that, well, let me just stop there first before getting too deep. Did I do an okay job summarizing that as somebody with a philosophy and law background?
Yeah. Yes. I actually think, here's my hot take. I don't think the revolution is in AI methodologies. I really think the revolution that empowered us to do this was on the hardware side. So it allowed us to make many more computations. If we were back 10 years ago, we'd still be trying to use traditional Bayesian algorithms to predict outcomes. That's no longer what we're doing anymore. We're using deep neural nets, which are just millions and millions of randomly created stochastic functions.
Yeah, and so I think one of the problems with folks wanting to adopt a technology like this is you're putting it into math terms, even probabilistic, that is something that seems to be very human. But at the end of the day, isn't it just an illusion that like humans are actually making the right decisions anyway? Like it's still probabilistic. That like it's like, think about criminal law, beyond a reasonable doubt. They have to, prove that they committed the crime beyond a reasonable doubt. Well, it's probabilistic that they did or didn't do it, right? Like at the end of the day, it's not changing anything from the way our current judicial system works. You think that's right?
You're absolutely correct on the empirical side. I'm sure Jack want to say something that sounds a lot like Hume.
Right? We can get this for the Hume predictability, but I just want to say, like, people forget that we have a machine now. It's a flesh and bone machine called process. That's what it is. And process typically works like we just slap more humans on top of the problem. One judge, that's too few people to decide facts. Let's give 12 of them. It's just a number. It's a lot of people. Process is basically, if we just stack enough people, 12 people to a judge to a 3-person appeal panel, 3 people to 9 people on the Supreme Court, all with sort of credentialing along the way. If we just stack credentials and people on top of one another, we compensate for this fundamental fact, which is this: I don't know what you're thinking. Mm-hmm. I don't know. And there's no way to sort of manage the risk of what decision do I make based on what you might be thinking. So there is this fiction we all indulge in. If we just stack people and credentials, we fix the problem. AI does this much more mathematically. It actually offers a more concrete solution. Whether it gets there or not, we can debate. Me and Kimo think it does, but it's trying something that is not purely illusory, as again, I think the people stack of process is.
Yeah, but and this is why, and I want to ask about the difference between machine learning versus large language models. You could assume my audience has a slightly above average understanding of what those terms mean. But with the large language models, in a way, they are our progeny, right? Like they are trained based on all of the data that humans have made. And this is a reason why I'm happy to be included in training data, because I want to be part of the training set of our progeny, our digital progeny, right? And so I feel a lot better when you've got these large language models that are trained on all of human history and all the things that we've made and continue to make as we make them, that's the thing, or different versions of the way those were trained, because there's training data, there's reinforcement training, right? There's bias that goes into all of these, just like humans have bias. And so, Jack, to your point, why do we have so many jurors? Why do we have so many appellate, more than just one appellate judge or Supreme Court justice? Because we're trying to account for that bias. Mm-hmm. And so one of my concerns, though, with having, and maybe this is just a marketing thing, so Kimo, tell me if this is you're actually doing this, but I want multiple AIs. I want multiple large language models evaluating it the same way that have maybe similar or overlapping, but not identical training data, not identical reinforcement training, to come to these decisions to also help eliminate that bias. So going back to parroting the way it works in the real world, is Arbitris doing a version of that, or is it ultimately it's an AI making a decision at the end of the day?
Yeah, so this gets into more of a metaphysical question. Do you think voting ensembles are a single unit or different unit? They are technically different units. And it's also important to distinguish on a technical feature here. I don't want to obfuscate, because classifier models and transformer models, which would be the LLMs, are different, both technically and how they work in our system. The LLM models are largely, but not wholly, confined to our reasoning module, whereas the classifiers are most of the decision-making module. And that's because when it comes down to making judgment calls, you wouldn't just want predicting the next logical sequence of tokens. You'd want it looking at the actual substantive outcome, which is how actual humans make decisions, right? Mm-hmm, mm-hmm. So the answer is yes. We have multiple models making decisions, more like a judge panel, right? We call it a voting ensemble. When it comes to writing the opinion, we have a system called raw.ai. We named it after the Egyptian pantheon, right? Where each different agent is acting on its own specific, specialization. Just like with Egypt, you'd have the god of the sun, you'd have the god, you have all these different gods that have specific areas, specific jurisdictions, you might say. And so we have the same thing you have a statutory database, you have the private contract database the parties have uploaded, you have the factual content the parties have uploaded, you have case law, you have jurisdiction specific requirements, you have the common law, so you have cases, and all of that is relevant. And each one has a different role in picking out the most relevant information that then gets passed back to a master LLM, which, I guess you can criticize, but judge panels work the same. One person ends up writing the opinion at the end, even if all of them collaborate on what that opinion might look like.
Mm-hmm. Mm-hmm. And if you stack LLMs, and Kimo, let me know if I'm off on the tech. If this is my understanding, if you stack them up the way you stack people and process, something happens when they talk. They tend to kind of meld. They there becomes a hive mind among them. And this happens with courts too. If you've been around law spaces, you hear text, history, and tradition a lot. These sort of individualized grunts that we reply to in certain circumstances, everybody starts using them. LLMs are even more so of that, though, because they speak in ways that just sort of humans can't keep up with. They're speaking just volumes and volumes of data in conversation with one another. So you always do it with sort of just a hive mind machine. So if you think you're going to sort of paper over this by just stacking more of them and having the three biggest companies, LLMs, get in a circle, you might have that for a day or an hour. But pretty soon you're going to have one hybrid machine that you've almost in a way sort of lost control of.
Yeah, it's
correct.
So philosophically, we're all kind of just trying to achieve a hive mind by trying to understand what everybody's thinking, right? So AI mirrors humans in that way. Mm-hmm. So could AI engage in groupthink? Is that what you're saying, Jack? AI engages in groupthink.
I think it's a question. Kimo, what do you think about that?
Well, yeah, okay. So the answer is it depends. Our system, we've actually tried to prevent that. So this gets into a really good question on bias and security. So we do try to have the bots actually act in a quote unquote adversarial nature. Now, with humans acting in an adversarial nature, like policing other humans, right, is going to have, emotional or personal consequences. The bots obviously do not care. It literally does not change the way they are prompted or extracting information and then ranking cases. What it does end up doing is create lots of iterative processes. Now, humans are going to get really upset if you come back to the same memo for the 5th time and say, rewrite this for me, right? An associate doesn't want to say, like, spend 2 weeks doing something and then rewrite it again. The bots don't care. And so what we're able to do is create a highly iterative, refined process in which we're pulling the best information. And in some way, Professor Vermeil talks about this with how we actually conceive of administrative law and process. The reason you have these iterative steps, right? Jack pointed it out. You have multiple appeals, right? You have this iteration built into the system is because it gets better over time because there's more refinement that happens along the way. We do the same thing. We just do it all at once instead of waiting, years and years for a judge panel to review it. We just have different bots.
Yeah. So one of the things I remember listening to in the paper, since I converted it so I could listen to it while I was driving yesterday, is that what it does though is it takes, because of context window limitations, although like Gemini Advanced has like a 5 million token context window now, so like it's getting better and better, that it first summarizes everything and then makes decisions based on the summaries. So are you going to be moving eventually towards not having to do that? Or do you still think that there's value in first summarizing something, analyzing it, and then returning to the large text?
Yeah, so this was from a technical writing perspective. I probably should have specified what I meant by summary, because you're right. That is what it sounds like. Actually, what's happening is we're splitting it up by issues of controversy just because we need to decide them separately. There are issues to decide separately, and the classifiers have to know that, because the classifiers, unlike LLMs, they're much more static in the way the document has to be formed for them to make a decision. So that's just on the technical side. Yeah, context window is a big question. Now, there are problems even with the Gemini context window that transformers have, which is attention. And so we're waiting to see. We do a lot of internal experimentation, and then we try to publish that as we're confident in the outcomes. But there's already open source documents that larger context windows above about 120,000 tokens struggle to recall information correctly, especially in law, where very small tidbits of the information can be impactful. What do I mean? Like pin sites, right? Like if you get a pin site wrong, that could be really important. Whereas if you're in a philosophical paper and you get, page citation wrong, it's not going to be the end of the world. It could be the end of your job in an actual lawsuit or decision. Now, I don't think that's enough to overturn a case on the merits, especially arbitration is such broad discretion. But I do think it's something to consider when building these products, which is one reason why we split it up in issues of controversy. It's easier to handle. Now, sometimes we do have to summarize and split up cases. And I don't even mean cases normally, because let me think of a big one, Dobbs, right? Dobbs is a monster in a case. But even that case, it's only 120,000 input tokens. And even now with O3 Mini, I think it has a 200,000 token context window, so it could handle it and produce output tokens.
I would love to see, speaking of Dobbs, I would love to see Arbitris AI, what decision it would make based on Dobbs pre-Dobbs. That would be a great publicity stunt. Could you do that and publish that? That would be phenomenal.
Yeah, I don't know if I'd want to publish. I don't know if I'd want to publish on that exact issue. Yeah, so I will say you could look at our predicting precedent paper. I actually did predict the end. We predicted Dobbs. We thought Roe was going to be overturned. Now, I don't like to brag about that because, there are other legal scholars predicting that, but the AI was very confident Roe was going to be overturned.
It's not just Dobbs you predicted, Kimo. Tell them it gets
we predicted the whole term,
and it gets it down to concurrences, dissents. It knows who's writing what. It knows all these things. It's the first time I really got scared about AI was reading his paper.
So what you're saying is you did create AI God as a judge.
Not AI God. We're just predicting. I like to have a little bit of humility here. We were just predicting.
The Egyptian pantheon is what you decided to name. I thought OpenAI. I thought Sam Altman was creating AI God, but you beat him to the punch as a judge. Then is what it sounds like.
We can talk about AI again. We've got a paper coming out on God.ai, GoldenCalf.ai, and the
But this gets you down. I think the future of academia and legal philosophy is going to be much more technical, right? Because our conversation here, where it's interesting, is technical capabilities, and technical capabilities come to represent human reasoning. Like we talk about theory only insofar that it makes sense in reality. At least, some people don't, but don't talk to the postmodernists. But what I mean here is that, yes, we've been predicting this for a while. And actually, I was tempted to publish our predictions for the upcoming court. We actually did write a paper about this last year. A lot of law journals just don't want to publish technical papers. I submitted a prior paper on predicting precedent to get published. We went through 53 law journals. Now, obviously, it's always hard to get law published, right? Any professor would tell you that. But lawyers are stuck in the past. They're stuck in the gilded, medieval sense where what they're doing is an art. What we're transforming it into is a science. This is the age of industrialized law. And there's good reason for that. There's tons of demand. Yeah.
Look, I'm gonna pull on that thread because I'm gonna ask you next who this product is even for. And what I'm about to say relates to that. And so I have gone down market in my practice, right? I serve the latent legal market. And so I'm working with folks all the time who have never actually hired or worked with a lawyer before, or unless they had no other choice in the matter, right? Because my fees are predictable, they're low. People I've interviewed on my podcast fall into a similar boat. So all the time I'm explaining to them, and their minds are boggled. Law is more art than science. And I actually have this conversation frequently enough that I'm going to have an upcoming episode of the Law for Kids podcast about that law is more art than science, at least right now, because at the end of the day, humans are making decisions on stuff and you don't know what they're going to decide. So it's all art. It's like not science at all.
Right.
But I think the consumer wants law to be science, though. I think from at least from my anecdotal perspective, that's what the consumer of legal services wants. They don't want law as art. They want law as science.
Correct. I mean, if you ask any normal American, they just want to know what the outcome of their case is. They do not think, they don't talk about Erie and general law and, the implications on jurisprudential thinking. The average American just wants to have an outcome to their disputes done affordably. And they've been denied that. And yes, Jack.
The direction we want this to go in really is, the one thing you never do, textualism is big today. Nino Scalia, Kagan saying we're all textualists now. Text is big. One thing you never see anybody do is pull out the text of a statute, read it, and go, okay, I'm going to act now. The text, in terms of what we actually base our decisions on, is the last factor. So let's be very honest, where is this going? It's going to a place where judge.ai, or whatever we're calling this, it's not even really a judge. It is the statute. It is a statute that talks. It's kind of the end of the textual variant of law. And of course, the era of the textual law has been all time dating back to Hammurabi. This is a big deal. And this is why when we talk about where this is going, it's huge. We're going to reconceptualize what it counts as a law. And people will say, well, how can you have a law that's basically just a chatbot where you say, hey, is this legal? And it tells you yes or no. That's exactly what a statute is today. The text is for show. You go to the chatbot, which is a law office, and you ask us, and you pay us, guys like me, couple years out of law school, don't know hardly anything yet. You ask us at top dollar, what does that law mean? I don't know. My buddies don't know. But collectively, we all sit there. We know enough that, insurance will toss you some insurance money. You can bear the risk. Text is already kind of irrelevant in that sense, and that's why we want to replace it.
I actually like that a lot. I like that you're calling it an AI judge. But in actuality, what it is it's the statutes, the law personified. Right. And that, to me, is a lot more palatable. And so I wonder from like a marketing branding standpoint, Kimo, going back to you, why AI judge, and why singular?
Yeah. So, yeah, good. Maybe we should do that. From an arbitrist perspective, again, I was the tech guy. There's a lot of technical difficulties to fully personifying the law. Now, we are excited to release our next product, which is going to be embedded in Arbitrust. It will actually do exactly what Jack said. We call it on the academic side ex ante query. We're calling it a prediction service. It will actually break down the probabilities for each one of your contract clauses or issues in controversy and tell you your probability of prevailing. And so you're exactly right. It is the law personified. Now, I've
had people from my network, Kimo, already, just to let your folks know that they said, I don't want to use this in arbitration or dispute resolution. I'm going to use this internally to see what's my risk as a business owner, right? So there's already, from my experience, there's an interest in something like that.
Precisely. And that's also where, from a business standpoint, you can charge significant amounts because people aren't only seeing the process itself, they're seeing the actual substantive ends on their business. If you know ahead of time you have a 20% chance of prevailing on a certain clause, you can bet your butt you're going to be going and getting insurance on it because you're going to lose. Now, if the insurance company knows and you're hoping they don't right now, that's also a problem for you. So it's going to be this arms race of probabilities and bots and prediction matrix.
Yeah, and even so, and even the way that you've explained that there's multiple things going on in the background behind Arbitrus, like for me, what I would recommend to my clients, or even for myself, is you're a first mover, but there will be other competition. I'd want to run the gamut, like especially if it's affordable, and like just enter into a contract with the other parties in dispute. Like, let's run Arbitrus, let's run, competitor 1 to Arbitrus, competitor 2 to Arbitrus, and let's see where they all convene, and then maybe we're able to come to a resolution, even then. And so as a business, I don't think I'd care if I were you, because I'm still paying you, to do the thing anyway.
Yeah.
Right?
Yeah. That also assumes you still want to go to the public courts, though. So there's a second reason I think businesses will be highly incentivized to use Arbitrus as a private court, which is you can get financing on every single one of your claims. Unlike normal courts right now, it can be very hard, especially on smaller cases or cases where you're likely to lose or cases that are likely to go longer, because financiers will know exactly how to price those cases now, including cases where you're the defendant or you have a counterclaim and you have different policies based on that. So I think there's a good reason you'll want, even if it's not us, you'll want to use some sort of private court system to adjudicate your matters, simply because it's more predictable.
Right. And I do, you've got this impulse. I see you going back to a couple of times of stacking the products. And I think there's power in it being a singularity, especially as we sort of move down line, hoping towards sort of the law personified. What this really is, lawyers will understand this term, it's kind of an advisory opinions machine. Brief history. The first thing George Washington does when he gets in office, he wants to do some stuff. He's the first president. He doesn't know if a president can do it. So somebody's cabinet, Thomas Jefferson, young upstart, goes, I know what I'll do. I'll write a letter to the Supreme Court. And he asks him, calls him and say, can we do this stuff? Basically conscripting the justices, 6 or 5 at the time, as his OLC. That's a pretty smart call. If the Supreme Court tells you it's legal, it probably is. And they come back after long deliberation and without really any legal citation, they just say, no, we're not going to do it. And there's been this precedent. You can't have an advisory opinion ever again. But the idea has always sort of allured me, because why wouldn't they want to do it? Well, when you count the reason, it's all sort of human limitations. They get asked too many questions. People change in and out of the bench, just that there's not a singularity of voice, such that today's advisory opinion might not be tomorrow's. How does that work with lower courts? Do they get issued their own yada yada? If you have one judge for the whole system, be it a country or one contract, one judge, one voice that speaks with authority of law, I think you can have a system, not even advisory opinions, because they're not opinions anymore. They're advisory orders, perspective or late. They tell you how it's going to be. So I think having one machine is powerful because it is the one thing. If you've got 3, now you got to think of 3 options. Now you're diversified. There is power, even arbitrary power, in just being the one thing. You know what to change if you need to change. You know what to listen to.
Let me tell you about the brand new sponsor for Law Subscribed, Paxton. I've been using Paxton as my legal AI tool for over 2 years. I continue to evaluate and demo other legal AI tools in the market and still decide to stick with Paxton because of its reliability, its accuracy, its ease of use, affordability, and they do not lock you into a long-term contract. Now, as a transactional and fractional general counsel attorney, I'm using Paxton for all of my substantive and non-substantive legal work, whether that's legal research, analysis, drafting, or enhancing existing legal work product. In the time it used to take me to draft and analyze legal documents, now, after a little bit of back and forth with Paxton, I have something ready to go in minutes that used to take hours or even days. While I'm no longer a litigator, I could see how valuable Paxton would be when researching a new issue, preparing for a deposition, drafting a motion, or going to trial. So if your firm would benefit from using Paxton as your legal AI tool, then make sure to use the link in the description when signing up to let Paxton know I sent you. That's all about our new sponsor. Now back to the show. Yeah, well, we have about 15 minutes more on the schedule here for this interview, and I feel like we could talk for hours. So I do want to ask you a question about like the use of what large language models. Like, are you using the foundational models that we all know are out there, but with the enterprise API, so it's not training underlying models? And also, I want to know, are you leveraging any legal specific large language models? Because at least in my experience, and I'm a Paxton user, Paxton AI, they just raised a big round. They're leveraging a legal specific large language model. I've just found that it is significantly more accurate, and I have not run into any hallucination problems whatsoever in 18 months plus of using it. And so I find that having a legal specific large language model leads to significantly better outcomes when it comes to legal related tasks. So I'm curious to know if you're doing anything like that.
Yeah, so we fine-tune our own models in-house that all do different things. So again, in the raw pantheon, we have models that are fine-tuned to do specific tasks. We opted not to use a specific large language model because it just wasn't doing analysis in a specific way we wanted it to. Remember, when you're fine-tuning large language models, you're not only trying to prevent hallucinations. We actually have other methods for that, and I'm happy to talk about. I think that's actually less interesting of an issue these days. I think it's more about how you write it. How you go about a statutory analysis is very different than how you go about a case law, common law analysis, or even a contracts analysis. And so it's important to have models for each one of that. Now, obviously, if I'm going to say we're using open source and we're not using DeepSeek, that's a whole different conversation we can have. I'm not intrinsically opposed to it. I think there's a little bit of a China scare there, but we do not use DeepSeek. We use Llama. So we use variations of fine tunes. We use Llama 3 400B, great model. We also do use OpenAI occasionally. We must use OpenAI for pre-processing. Very simple reason for this. It is 15 cents per million tokens on OpenAI right now. It is $2.70 for deep infra. So it's much more, actually the open models are more expensive. Now you could have your own hardware in-house, and we have done that for some things. Some clients prefer it that way, but that's a large investment up front. And eventually you have to replace those servers. So the answer is there's a lot of models, and we haven't even dived in. We custom train our own classifier models through Azure. So that's a whole different modeling system. We have our own. We are beginning to experiment using small language models to do very small tasks. So there's even things like reread this opinion and pull the parenthetical for this rule, right? To check and make sure it's properly grounded. That's something a small language model can do. Liquid AI that just came out of MIT, we're looking to eventually incorporate that product. So there's just different tasks that need to be done, and all of those tasks we use different models for.
Yeah, so going back to the paper, there were quite a few hypotheticals in there, which was nice. I mean, I know you said in there it was artificial cases to run through the arbitrus.ai system. But what I noticed is that a lot of them were like even some types of cases that I've worked on as a former insurance defense attorney, right? And so these are cases that already have attorneys, like disputes that already have attorneys litigating and stuff. But the largest market opportunity, and something that you also mentioned in the paper, is like, helping these small disputes where there are no lawyers. So, how many pro se litigants did you talk to? How many solo attorneys who have actually helped, been the only attorney on a case? Like if it's actually potentially being used for the, all these small disputes where it costs a lot of money to even file your dispute in court. Like what's been the research done on that side? And I'm realizing that there's a glut of data, but you can go out and still collect some yourself.
Yeah. So we've done some internal market research on consumers. In fact, we have a consumer app right now out called Casecraft. And the best research you can ever do is see how actual users are paying to use your application live.
Yeah.
And that's what we did. So we went out and we were looking at what cases. So to be transparent, our privacy policy allows us to train on all their data as long as it's anonymized. Again, I think people should be less paranoid about that, but we like being very transparent. So we actually went and looked at the types of cases they were looking at, how they were using it, right? People talk to the chatbot about a lot of things. Our chatbot actually lets you draft templates, right? It's designed for the consumer. And in fact, we even tried to make it so simple that you could just click through the system and you almost never have to type anything but your initial query or upload document or whatever system you want to use. And so we did a lot of market research that way. We actually have an internal memo called an Arbitrus query memo. We spent almost a month running different statistical analyses on consumer behavior. Almost all of them, more than half of them, were essentially using it for arbitration, or an equivalent, going before HR because you came into work and you were intoxicated. That's a arbitration type case. We receive a shocking number of those. I was actually surprised. I thought people would be using Casecraft to learn about the Constitution, but apparently not everyone's a legal nerd like me. Actually, our largest use case is for personal family disputes. People are going through divorces, which is actually why we ended up uploading marital contracts to the arbitrum system, because most of the users are using it for that. They want to use it for their everyday disputes. And so this was a learning process for me, is how people actually interact with the law.
And my whole hypothesis for my practice and how I think the future of law firms should be is that there's massive market opportunity here. You just can't bill by the hour, right? And so how are you charging these people? Is it a subscription? Is it a per use charge? How does it work?
Well, imagine it. We're talking about arbitrum here, not casecraft. So
I'm interested in casecraft too, frankly.
Yeah. So arbitrum is a very simple billing model. You pay $27.50 per contract, and it locks in the price. Now, you want to lock in the price because prices could go up considerably, actually, especially as demand increases. If you read one of the drawbacks in our paper for very accurate decision making is computation expense. And so we guarantee if you purchase a contract policy number, you'll be at the lowest rate we offer. So that's either at the time you buy, or in the future, if maybe we have some government system that offers compute at a lower rate. Or you can, if you're a large enterprise, you can purchase a policy plan from us and it'll automatically cover all of your contracts, just like a straight insurance policy. And then when you come to dispute, we sort all disputes between two types, just like the AAA and JAMS does, which is either complex commercial or consumer. If it's a consumer complaint, flat $500 fee, and then it goes up depending on amount in controversy. With complex commercial, it starts at $5,000, flat fee, the entire process, and then it goes up based on amount in controversy. And then the prediction services, you will get a comprehensive draft back, which comes with the probability behind every issue in controversy. We'll actually have a standardized ranking system depending on jurisdiction. So eventually you'll actually be able to analyze your claims. Like if I have a form of law, if I'm selecting form of law in Texas versus New York versus California, and you'll be able to actually weigh your odds with the different models. Then we charge a flat $2,500 for that type of prediction service.
Yeah, interesting. And then for the casecraft, I'm sure I could go look it up if it's public.
Casecraft, so you better use casecraft while you can. It's $20 a month, which is cheap. It is built for consumers, I will say that. So It's not the complexity of arbitrum. To put it in perspective, it costs us almost nothing to run casecraft. We run it on purely open source models. You have none of the proprietary models that we use in arbitrum, but it still is a very useful system. We use the same data. So we've harvested the same data from every single case across the country. We built our own head note system, and you get all of that for $20 flat per month. Now we'll see how long that lasts, because maybe I don't want people using casecraft if I have an arbitrum system that has similar head notes built into it, but we'll see.
Well, if you could make money while collecting data, why wouldn't you?
Exactly. Yeah. Casecraft is the peak. We have so much data we've generated from casecraft now. We have billions, and I think per month we were going through at some point like 30 billion tokens. And all of that is incredibly valuable user marketing data, which is how we built part of arbitrum out.
Okay. Well, the way that I'm going to wrap up this interview, and I will leave some room for a call to action if folks want to follow up and all that, is, and Jack, we're bringing you back in because this is I think it's more of a theoretical question too, but there's a business side of this as well. And that is, in the beginning, Kimo, you talked about you're trying to parrot the real process. And even in my original notes coming into this conversation, after listening to the paper, I was like, why mirror the original system at all? We're talking about a private court system here. Can't you make improvements? Can't you make it better? We make a lot of the decisions of our current process because of physical constraints, going back to the physics of it all, and human capital constraints. So why mirror the process? If we're starting a new society, if we're starting a society from scratch, why mirror the existing system at all?
Matt, that is a fantastic question. Something me and Kimo discuss a lot. I think in the short term, you want people to be able to grasp things they're familiar with. But make no mistake, I think Kimo wouldn't mind me saying this, the way this is really working at bottom is that this thing is your contract. It knows your contract. You give it facts, decision. You can file out other stuff to informative facts. A lot of this just sort of is discovery. You give a witness interview, yada, yada. But, briefs, various rounds of briefing appeals, these are nice things. And at the margins, they can kind of inform the machine a little bit in the short run. But to be very clear, once this thing sees the facts, yes, it is perfectly capable of that bing decision. And, I always joke around. We ought to give it a processed slider. And what would the process slider do? The process slider is if you move it up to max process, it lets you wait 2 days or 2 months or 2 years before you get your result. And if you put it down to 0, it tells you right now. That doesn't ever change how long it deliberates. It gets it in the same 2 seconds, just how long it holds it. And I know we've had some trials with this where people vastly preferred the 2-day wait to the 0-second wait, which is hysterical to me because nothing changed. People just equate. They've been so beaten down and conditioned to equate time with accuracy. Well, what we're trying to do is algorithmatize the system of life. It's the one game theory from chess. Chess is a solved game. That's kind of what we want to do here. There are facts, they are objective, and machines are great at giving you objective answers right now, not later, now. And the question becomes, if your law is not objective enough to turn into that level of facts, do you have a legal system? And I think a lot of legal academics and sort of entrenched legal formalists who appeal to sort of fuzzier notions, general law, common law, they need to think about that. If it's not algorithmically factual, is it real?
Right.
Jack is...
Go ahead.
Yeah.
Go ahead, Kimo.
No, and Jack alluded to some of the internal experiments we've done, and I am eventually, when we probably get some VC funds, going to do an experiment on this because I love the idea of the process slider, right? I think that just kind of satirizes what a lot of attorneys like, but we've done a lot of internal research and demonstrated that attorneys like when there's more steps. The steps don't actually change outcome often, right? Having an oral hearing is probably not going to change the bot much, especially if you're not doing anything about interviewing the facts, right? You're just arguing what you put in your brief already. And we kind of know that intuitively. If you actually ask a lot of judges, they've made decisions by the time they've read the briefs. They don't need the oral arguments. Now, oral arguments could change things theoretically, but it's very unlikely. And so people are much happier when the process takes longer. So
Yeah.
That's
Look,
the reason.
I remember like that because I listened at 2 times speed, and so I'm sure I didn't capture everything into my long-term memory. But that stood out to me because you explain that in the paper, and I think we're even still experiencing that with AI a little bit. Whether it's Google's deep research or OpenAI's deep research, like you give it a research task, it takes 5 or 10 minutes to come back like with the research task, even AI, right? And there is like an understanding problem with the way legal professionals in particular, but I think the public at large thinks about AI. They think about it like a machine, going back to what Jack was saying. But when you program a calculator that 2 + 2 = 4, that's an immutable truth. It will always get 2 + 2 = 4. Language is made up. We made it all up. And that's why the probabilistic models of large language models make a lot of sense. So like, what is a hallucination? Did it make something up, or did just the low probability outcome happen, right? It wasn't like a high probability thing.
I get so angry when judges talk about sort of the law running out.
Yeah.
You guys made these fake physics up yourself.
Right.
If it runs out, fix it. There's no deeper sort of epistemology to this. You made it up. If it's not a series of facts, fix it. And of course, that's what a court system is. It's an ex post fixer machine. You take the case, they say, oh man, the legislator didn't think of that. We'll patch it in reverse. All our thing does is patch it on the front end before you're ever on the line, before you've ever even acted.
Yeah. And so I'm happy to have you guys back in a few months, after we see what happens, because I'm sure we could talk for hours. One of my last notes that I took is, Jack, you said Bing. Is Microsoft sponsoring you?
Bing, not Microsoft. There are various things out there, but Bing encapsulates a lot of what we're doing here.
I get it.
Binging, yeah.
Yeah. So the last thing I'll say is, I think as far as like enterprises are concerned, I want to reference episode 97.5 for the listeners, because I interviewed Jim Sullivan, who's the co-founder of eDiscovery AI, and they're taking a very different approach with eDiscovery. We even talked about the proactive potential nature of an eDiscovery platform that's used after something goes wrong, and then does the eDiscovery process of finding all the documents and analyzing them and now they leverage large language models in addition to machine learning. But like being proactive about that seems like it'd be easy to plug in a proactive eDiscovery like platform, because it's not eDiscovery anymore because you're proactive with it before litigation, into an arbitrous type thing where now you've collected all the data because it's built into your systems. So like, I think, like, I don't know if we're going to be there yet, but this, my prediction as like a legal tech futurist, I think there's going to be some potential interplay between what the future of eDiscovery looks like and what arbitrous AI is doing. So that's just my prediction. Any crystal ball predictions for either of you before we wrap up?
Yeah, my crystal ball prediction is next they're going to start building, at least on the consumer side, AI attorneys. And you're going to push one button in Arbitrust as a consumer, and the AI is going to write everything for you. So law firms are either going to get on board and they're going to provide, you're going to have the Jones Day bot you can hire. You can hire the Hutch Blackwell bot. You can hire whoever's bot, or they're going to get left behind.
And I think that's about a 10-year plan. But I think even later on, the idea of even an AI lawyer will be outmoded. Because here's what I think. If we notice what we're talking about here, when the statute becomes your judge, it becomes your lawyer. We've really kind of commenced that separation of powers. And what we're talking about also is a legislator. There is no more judiciary. When we talk about queries, when we talk about the data we have of people typing what they want, we sort of have ideas of what they want the law to be. I see huge potential in the distant, or maybe not too distant future, for this as a legislature. We've got papers coming out on this, sort of the central orb that knows more about you, the way Netflix recommends you the show you didn't know you wanted to see. Can a robot give you the law you didn't know you wanted? Can law making, as opposed to law interpreting itself, be a solved game? That's my crystal ball prediction. It scares the hell out of me, Matt. But I think this thing, more than a judge, is a law and a legislator.
So everyone that we might have just lost, before we lose you, I'm just going to pull it back. I'm going to pull you back from the edge here. And I'm going to say, I think all of this is actually not even that extreme. I think what we're going to see is AI enhancement of very human things. I think I think lawyers have to price their legal services right. And if they price it right, like, for example, 93.5 episode of Law Subscribed, I had Julia Rogers from Hello Prenup on there. The automations make the prenup. I've seen every iteration of this prenup, but it's still good sometimes. The automations can't handle everything. And so they still like to hire lawyers, also because there's some case law that says you probably should if you want a more enforceable prenup. But they still are paying for lawyers to look at it, but we have to agree to a lower fixed fee to be providers on the platform, right? And so there's already this automation plus human lawyer AI hybrid that's going on with productized legal services. And so I, for one, welcome it because I'm priced accordingly. And so I'm not afraid of it. But the law firms out there, bringing it back to the concept, this approach with Law Subscribed with the podcast, you have to rethink the billable hour. Because I agree with Jack and Kimo here that we're going to be moving towards this future. I don't know when. We're in the middle of an exponential growth curve. So, it's hard to know when things are going to happen. But with all that, again, we could talk forever. We'll do Kimo, then Jack. Just wrap us out. If people want to follow up with you, sign up, all the socials, all that stuff, where could folks do that?
Yeah, absolutely. So if you just go on to our website, arbitrus.ai, it's right there. Or look us up, fortunainsights.com. You can find it right there too. You can find us on LinkedIn, Twitter, Facebook. Hit us up. You can hit me up either in my DMs in LinkedIn, Kimo Gandall. You can email me, kimo.gandall@fortunainsights.com, or email Jack, jack.kieffaber@fortunainsights.com, and we'll respond to you ASAP. It's very easy to integrate into our platform, into whatever you're doing, whether you're writing contracts, you have active disputes. Go on the website, and there's 2 clicks away from having your dispute arbitrated.
Bing, this stuff's coming, and please plan accordingly because it's not even coming. It's here.
All right, you two stick around as we go off live for the live viewers, listeners. Thank you for participating. Jack and Kimo, they were just saying they're enjoying the conversation. We didn't actually get any questions that weren't already addressed. So thanks again. We'll sign off now. You two stick around. And LinkedIn, thank you very much. And that's a wrap. Thanks for tuning in. Make someone's day by sharing this episode with them. The best way to get in touch is to follow and message me on LinkedIn. To get extra content, subscribe to the newsletter at www.lawsubscribe.com, where you can also become a paid subscriber to get episodes and content early. Until next time, this is Matthew Kurbis with Law Subscribed.